Today, I'm very proud, along with my colleagues in the Southern Regional Office, Tara Borelli, with the support of our partner, our state partner, Georgia Equality, and along with our co-counsel at the law firms of Brian Cave and White and Case, to announce that today we filed a class action lawsuit asking the court to strike down these discriminatory Georgia marriage bans. We filed this lawsuit today, simply put, because marriage matters. It matters to our plaintiffs, it matters to their children, it matters to thousands of same-sex couples across Georgia who are either married, who want to be married, or who may someday need to be married. We filed this lawsuit because marriage matters, because it confers not only rights and responsibilities, not only privileges and protections, but a status and a dignity that cannot be created by any other means. It directly and universally designates that couple's relationship as permanent and committed in a way that no other word can do. We filed this lawsuit because it is unjust to single out some citizens, like our brave plaintiffs, and treat them as less than, to send a message to their children that there's something wrong with their family, which is exactly what Georgia marriage bans do. It's discrimination pure and simple, and it's wrong. And through our lawsuit, we aim to eliminate this discrimination, which has no place in a country built on equality and liberty, where every person has the right to life, liberty, and the pursuit of happiness. And while our system of government hasn't always gotten this right along the way, we get it right in the end. And for same-sex couples in Georgia, the end is in sight. I'm so proud to represent the plaintiffs who are standing behind me and who are standing up for all Georgia couples, all same-sex couples who are married or who want to be married. The plaintiffs in our lawsuit include Christopher and Shelton, Michael and Shane, two committed same-sex couples raising children, living ordinary lives filled with the extraordinary joys and challenges of parenting. Their families seek the protection of marriage. These couples want to be bound by its obligations. And yet the state in which they live, in which they work, in which they own businesses, pay their taxes, attend their churches, help their neighbors, and just live their lives tells them that they are unworthy and unable to make perhaps the most intimate, personal, fundamental choice a person can make, who they can marry. The plaintiffs in our lawsuit include Avery and Rayshawn, who are legally married in 17 states and the District of Columbia and dozens of foreign countries, but not in the state in which they live, not in Georgia, even though both women risk their lives every day as Atlanta police officers, even though Avery is in the United States Army Reserves, even though they put their lives on the line for their city, for their fellow citizens, for their country, the state in which they live will not recognize their marriage. Not even for purposes of the Family Medical Leave Act, the federal law that allows them to keep their jobs when they need to care for each other or in times of deployment. In fact, were either of them killed in the line of duty, Georgia's marriage bans would mean that the benefits provided to all other married law enforcement officers, which are designed to support the spouse of a fallen officer, would be blatantly and blanketly denied to them. The ways in which Georgia's discriminatory marriage laws are enforced are especially cruel in times of tragedies and crisis, which is why Jennifer Sisson finds herself a plaintiff in this lawsuit. She seeks recognition of the marriage she entered into in 2013. Sadly, Jennifer lost her wife, Pamela Drenner, barely 1 year after they married on Valentine's Day 2013. Pam died of cancer March 1st, 2014. And not only did the state of Georgia refuse to recognize their marriage when Pam was alive, it refused to recognize her marriage when she died. And it continues to do so to this day. Which means that even though Jennifer married the woman that she loved and cherished, even though she upheld her promise to care for her in sickness and in health until Pam's last breath, because of Georgia's discriminatory marriage bans, the funeral home would not allow her to be treated as next of kin. And the death certificate, Pam's death certificate, designates her as never married. It's inaccurate, it's unfair, it's permanent. Our lawsuit seeks to reverse these painful and pointless state actions by Georgia, to ensure that Christopher and Shelton and Michael and Shane can get married and protect their families, to ensure that Avery and Rayshawn are treated equally, to make sure that Pam and Jennifer get the dignity they deserve, and to make sure no other widow is treated so tragically. This lawsuit is not the first. It is the 65th as of today, but it may be the case that makes it to the Supreme Court. It may be the case that removes the barriers that keep some citizens less equal and some families more vulnerable. There's no debate that the laws we challenge in this lawsuit discriminate on the basis of sex and sexual orientation. The only question is whether the state has legitimate reason for doing so. We're confident that we will prove that Georgia's marriage bans are lacking any rational basis, let alone the high standard they must meet when they infringe on a right so fundamental as the right to marry the person you love. It may have taken some patience and persistence to get to the point where marriage laws are gender blind, but we're on this threshold now. And considering that more than half of America now believes in marriage equality, there's no turning back. I've said the word proud and privileged a number of times. I'd like to say it again in closing. I am so proud. I am so privileged to be part of this lawsuit. Because when the dust settles on this period of history, what matters will be your marriage to your spouse, not their gender and not your neighbor's marriage. And our nation will be stronger, having expanded freedom and stayed true to our ideals. Thanks. Momentum is behind us. There's an unbroken string of successes in the federal courts. And we've thought very carefully about this, about particular challenges that we'll face in this jurisdiction. And we feel confident that we've chosen the right time to bring this case now in Georgia. We've heard from lots of couples across Georgia who are seeking the right to marry or to have their marriages recognized. And so it seemed that this challenge was particularly appropriate to bring a class action to settle this case once and for all, and to make sure that all couples across Georgia are able to marry and have their marriages recognized.